Good evening, class, and welcome to our taxation class this evening. Today, the topic under consideration is tax dispute resolution in Nigeria. So, what are some of the things we stand to gain in this class? We are going to be looking at the composition and jurisdiction of the Tax Appeal Tribunal. We will also understand what constitutes an appeal. We will also know the procedure for raising objections to tax assessment. We also know the procedure for hearing the appeals. Then we will also know the procedure to be followed for further appeals to the High Court, Court of Appeal, and Supreme Court. Then we will know the taxpayer's rights in a dispute. So let's dive right in to our core discussion. Now, whenever a taxpayer is doing business, we expect him to make a profit. And when he makes a profit, he is expected to pay tax on his profits. So sometimes these taxpayers, or many times, they are required to assess themselves, their performance, and to give themselves what is the fair tax that they are supposed to pay to the government. Sometimes these taxes received by the government, when they are examined, they find out that sometimes it's not fair on the government. Sometimes taxpayers try to pay lesser than what they are supposed to pay, and the tax authority decide to do something called additional assessment. So there is a difference between self-assessment that the taxpayer will do and the assessment done by the tax authorities. So where a taxpayer receives a notice of assessment from FIRS, let's use that from FIRS. So we are talking about a company and the FIRS. So anything we talk about here also applies to the state internal revenue. So where a taxpayer receives a notice of assessment from the tax authority, it's either he will agree with the assessment or he will disagree. So if he agrees with the assessment, the position of the law is that that tax that has been agreed upon by both the tax authority and the taxpayer will remit it during a statutory time limit of 60 days from the date of receipt of that assessment. So let's assume that on the 1st of September 2024, you receive an assessment from the FIRS, and let's say they say your tax is 1 million naira, and you are agreeing with it, you are happy with it. You have between the 1st of September, you count 60 days. So by October 31st, you should have paid that tax. That is the position of the law, 60 days from the date of receipt of the assessment. Now, what happens when you don't agree with the assessment? So the FRS serves you a notice of assessment, and you are not in agreement with it, what should you do? Then you are expected to raise a notice of objection. Notice of objection. So you object to the assessment given by you. Now, how do you raise the notice of objection? What is a valid notice of objection? They gave you a notice of assessment, yes, and you are not happy with it. What is a valid notice of objection? A valid notice of objection will have the following characteristics. So, we give you a notice of assessment. A valid notice of assessment or objection will have the following characteristics. One, it must have been made in writing. So it means that you cannot use verbal objection. So they give you a notice of assessment, objection, they give you a notice of assessment you are not happy with. You don't just storm the office of the FIRS and say, how dare you give me this notice of assessment? I object to it. No, 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 no. This is not fair. This is not what you're supposed to do. You are doing that all orally. That is not valid. What is valid is take your pen, put it down on paper, write a valid objection, and send it to them. So it must be made in writing. Now, second factor that will make it valid, it must be done within 30 days of the receipt of the notice of assessment. So it means if you have it, your notice of assessment was, or yeah, notice of assessment was given to you on 1st of September, and you are not happy with it. Before 30th of September, you should write your objection. Otherwise, when it gets to October 1, the 30 days has passed and it can no longer be valid. So you have your 30 days within which you will decide, are you objecting? What are your reasons? I'm going to put them in paper and I must do that within 30 days. The third point here is it must contain the grounds for objection. So you have to state the reason why you are objecting. You don't just say, I object. Let's look at the people that use objection a lot, the lawyers. When you are in the court and you hear a lawyer say, objection, my lord, it doesn't stop there. It states why he's objecting. The same thing happens here. When you are objecting, you are raising a notice of objection to the notice of assessment. You must state the grounds upon which the objection is done. It must be done in writing, it must be done within 30 days. Now, what happens when you have written your notice of objection and you send it to the FIRS within 30 days? The relevant authority, we are using the example of the FIRS, will examine this notice of objection. They will look at the grounds we are using in objecting, and they're going to determine whether it is valid. So if you state objection that are valid, they will look at it. Oh, this player has a valid point. Okay, so let's consider what he says. So where the grounds are found to be valid, the tax computation will be amended. It will be reviewed, it will be revised and amended, and they will raise an amended assessment. So instead of the original notice of assessment, they will raise something called an amended assessment. Then when you receive that amended assessment, that's it here. You have to get an amended assessment. It's called a revised assessment or amended assessment. When you get that and you are happy, you will have within 30 days for which you will make payment. So it means you're happy with that? No problem. Now, what if the tax authority looks at your objection and they find out that it lacks merit? There is nothing in your objection that is valid. They believe that you are not making sense. They believe they are right and they say, no, you have to pay. In that case, the tax authority will raise a notice of refusal to amend, also called NORA. Notice of refusal to amend, NORA. So they send you an assessment, notice of assessment. You are not happy with it, you write back objection. You have notice of objection, NOJ. They send you an NOA, notice of assessment. You write back. You give them a notice of objection, NOB, NOJ, NOO, right? NOO. Then, if they are happy that you've made sense, they give you a revised assessment. If they are not happy, they give you a NORA. Now, when you receive this NORA, notice of refusal to amend, it will state that they are refusing, they are adamant, you must pay that tax. Now, when you receive a notice of refusal to amend, the tax authority will give you another 60 days within which you should pay that tax. If the taxpayer is aggrieved by that NORA, what should he do? Because here you have tried to reason with the tax authority. The tax authority is not shifting ground, neither are you shifting ground. You are not happy, they are also not happy with you. So you have within 30 days to file a notice of appeal to the tax appeal tribunal. You have 30 days from the date of receipt of the refusal to amend. So 30 days. So 30 days is what is required. If you stay to the 31st day, it means that you have agreed to the assessment. So just as you had 30 days to object when the first notice was given, you also have 30 days to appeal the decision of the tax authority when they refuse to amend. And you are making your appeal to the tax appeal tribunal. Now, what are some of the relevant information that should appear in your notice of appeal? What are some of them? Your tax file number, which is the assessment number or your tax file number, yes? And so there's each taxpayer have a file number. You should know it. Now that filing is done online, so you should know your file number. Then you have the relevant year of assessment in dispute. It could be, let's say, 2022 or say 2023. I think now 2022 was what the authorities are currently reviewing as at 2024. It's possible that they will started reviewing 2023, but mostly now it's 2022 that they are reviewing in 2024. Okay, so the year of assessment could be 2022 or it could be above or um, before 2022. It could be any year. So what is that year that you refuse to uh, uh, that they refuse to amend the assessment that you are filing That's year of assessment. You, sh- you should write in your notice of appeal. Then the date that this NORA was received, that date you received the NORA. Of course, the NORA will have a date where it was written. The date you received it, you need to state it there. Perhaps this company have stamp where when they receive a particular letter, they stamp it and it carries the date of receipt. Then there is the assessable profit for the year being disputed. So that year of assessment, what is the assessable profit for that year? You should carry it in your appeal notice. Then after carrying your taxable profit, assessable profit, you need to also state the taxable profit. When you state the taxable profit, then you have to state the tax that is being disputed. How much tax are you arguing with the tax authority? Then you will state the grounds for appeal. The grounds for appeal. Now note, the grounds for appeal may not be different from the grounds of objection. So the reason for objecting in the first place should also be the same reason for appealing. So it means that when you are crafting out your notice of objection, you should craft it well in such a way that if they refuse, you can take it further with the tax appeal tribunal. And so it is going to be the same notice of objection which you are now writing in your appeal notice, and it becomes notice of appeal. So these 7 items are the fundamental things that will be found in your valid notice of appeal. All right. Now we have seen a chain of activity. The taxpayer ends its year of assessment or ends a year, yes, a year of assessment. It prepares its books, prepares its assessment, and give a self-assessment which it files to the tax authority. Tax authority receives this assessment, looks at it, and if they are happy, they take it that way. That's fine. If they're not happy with the assessment, they'll write back and say, no, this is our own assessment. So they give you a notice of assessment, which you will have within 60 days to make payment. Within that 60 days, you have 30 days to object. So the taxpayer writes a notice of objection within 30 days if it's aggrieved. This being received by the tax authority, they look at it and they say, oh, your this valid point that you've made in your objection letter, let's take it, and they will return with a revised assessment. So what they have given you before, they are revising it. They say, okay, we are agreeing with you. Pay what you said is it because we agree with your point. So take it, let's have it that your way. But now it's important. It is also possible that when they look at your notice of objection, they might look at it and it lacks merit. It is not, they stand their ground. They can decide to say, all right, we refuse to amend. And they gave you a NORA. Ah, you now say these people have refused. You are also not going to agree. Then what should you do? You file your objection. This time around is called an appeal to the tax appeal tribunal. We've seen the information required in an objection letter, that is an appeal letter or appeal notice or notice of appeal. The other one is objection notice. Must be in writing. It must state the grounds and it must be done within 30 days. The same thing with notice of appeal. It must be in writing, state the grounds, appeal, and it must be within 30 days. Every other thing that has been said here in the seven items that must appear in the valid notice of appeal. Now let's take a moment to look at this tax appeal tribunal that you are appealing to. Who are they? What are they doing? All right. The Tax Appeal Tribunal was established by Section 59 of the Federal Inland Revenue Act as provided for in the fifth schedule. So the Tax Appeal Tribunal is an administrative arm or body established by the Federal Inland Revenue Service Act to hear and resolve tax disputes arising from all federal tax legislation. Okay, so though they are uh, established by the Federal Inland Revenue Act, they are also independent from the FIRS. Now, this appeal tribunal is powered by law to hear and resolve tax disputes that arises from company income tax, company income tax, personal income tax, Petroleum Profit Tax Act, Value Added Tax Act, Capital Gains Tax Act, Stamp Duty Tax Act, Taxes and Levies Approved for Collection Act, all regulations or rules issued in terms of this legislation and any other laws subsequently passed by the National Assembly. So when it comes to tax matters, all the laws relating to companies tax, personal income, value added tax, capital gains, all of them, they have the jurisdiction to hear these cases and to resolve it amicably. They could resolve it to the satisfaction or to the benefit of the taxpayer at the detriment of the federal inland revenue, or they might handle it and it favors the federal inland revenue and displeases the taxpayer. So though it was established under the FIRS Act, they are different independent body. The tribunal is the first forum for any aggrieved person, be it taxpayer or tax authority. That's the first place you should go. So it means that if you are not agreeing with the tax authority and they have given you a refusal to amend, so you could rush and go to the tax appeal tribunal and lay bare your complaint. It could also be that the tax authority will be the one to go. So it means that he who goes there is the plaintiff, then you are the accused that is coming, that is being dragged. So the tax appeal tribunal is the first point of call to litigate, to lay your complaint before you approach the High Court. So you don't just go and approach the High Court. You must have done it first in the tax appeal tribunal. And it's possible that when it gets to the tax appeal tribunal, it ends there. Now, where is this tax appeal tribunal operating from? Where are their offices? Now, there are 8 zones, 8 zones of the tax appeal tribunal. So we have 6 in the 6th geopolitical zone. So this is 1, 2, 3, 4, 5, 6, the 6 geopolitical zones. So for the north central, I think we have Kaduna. For the northeast, we have Bauchi. Then for the northwest, and not is it north or northwest? Northwest, we have Jos. So all of these are for the north. Then for the south, we have the southeast in Ibadan. We have the southwest is in Ibadan, southeast is in Enugu, then the south in Benin. Then we have 2 standalone. One of them is in Lagos, which serves only Lagos. Then the other one is in Abuja, that is the head office, the seat where the head office. So there are 8 geopolitical, there are 8 uh, tax appeal zones, 8 tax appeal zones across the federation. So it means that if the people of Southeast, if there is a dispute in Enugu or in Imo State or in Abia State or in Anambra or Ebonyi State, they will all, if they want the tax appeal tribunal to hear them, they will have to go down to Enugu. If we have people in Delta State, Edo State, Rivers State, Bayelsa State, Akwa Ibom State, they all, any of them had issue that needs to be settled by the tax appeal tribunal, they will come to Benin. If there are people in Ogun State, Oyo State, Osun State, I think Kwara State is there, and all the southwest, they will come to Ibadan. People in Abuja, no, people in Kaduna, where again? Kano, and some other places that are near there, the north, they go to the Kaduna. Then those in Jos and the area near it, they go to Jos and that Bauchi. Then Lagos, all those only in Lagos, they all go to Lagos. So you can't skip your zone. So even though you are in Ogun State, that is very close to Lagos, you need to go to Ibadan, which is Oyo State. All right. Now, look at the according to the Act, the Minister of Finance may, by notice in the Federal Gazette, specify the number of zones, matters, and places to which the tribunal may exercise jurisdiction. Now, what are the composition of the tax appeal tribunal? What are the composition? How many people make up the tax appeal tribunal? It consists of 5 members. So we have 5 members in a zone, and we have 8 zones. So we have 5 members in a zone times 8 zones becomes 40 tax appeal commissioners. So tax appeal commissioners, they are 40 in number, and there are 5 in a zone. 5 in a zone, They are appointed by the Minister of Finance. Now, each zone shall have a chairman, and the chairman shall be a legal practitioner, not an accountant. At least he must be a legal practitioner that has been so qualified to practice for a period not less than 15 years. So he must have a cognate experience in tax matters. So you can see why people in the Nigerian Bar Association are joining CITN because of tax matters. So for you to also be a chairman, you must be a member of the CITN, which is the body that is charged with the um, administration of tax in Nigeria. So the chairman must be a member of the MBA, must be a legal practitioner for not less than 15 years. Now the chairman shall preside at every sitting of the tribunal, but in case he's not present, the members shall appoint one of them to act as chairman. So maybe it could be that the secretary, maybe the acting chairman. It could be that, okay, no, we still need the secretary to perform the secretary job. We could appoint another person to act as chairman. Okay, so they must have a chairman at a sitting. So if the original person appointed as chairman is not present, maybe it could be he traveled, he's sick, he's not capable at that moment, they will have someone who will preside. The quorum at any sitting is 3. So there are 5 members and the meeting cannot start until there is 3. Now, why 3? Why 5? Of course, there can be 4, but not less than 3. The reason for 3 is that they could take a decision by vote and the majority carries the vote. They could take a decision by vote and majority carries the vote. And sometimes, if there are 4 and there is a tie, it could be that the chairman's votes can be counted twice. But when there are 5, they are also going to have a majority. So 3 is the minimum for any sitting. But I've seen most of the tax appeal tribunal sitting, all the 5 members usually sit. Now, the tribunal may conduct its hearing remotely. Okay, according to the Finance Act 2020, paragraph 20 of the 5th schedule, it can now be heard remotely by means of such technology or application as may be necessary. Just the way we are having our Zoom class here, they may have a video conferencing via Zoom. It could be recorded. Of course, they will not have this meeting by WhatsApp. No, they may have either Zoom, Google Meet, also Teams, Skype, anything that they think is necessary if physical meeting is not possible. This is made possible because of the COVID era, where people are told to do social distancing, and then they amend the law that it could even hold remotely. And so this could even prevent, help the people from traveling, making that huge distance to come and have this hearing. So it could be recorded for control purposes. All right. During this meeting, the tribunal shall have the power to conduct its proceedings in a manner it deems fit to ensure speedy dispensation of justice. The hearing of an appeal shall be commenced by the appellant That is the one who is appealing. This is the plaintiff, the appellant, the one who drag the tribunal to come, who brings them to come and judge. So they will commence by asking the appellant to present documents and statements which he intends to rely upon. So the appellant is the one who brings this meeting, who calls for this meeting. Okay, they will bring him. Okay, you've called us here, right? Okay, tell us why you call us here. Then let's assume that the appellant is the taxpayer. They will now come and say, okay, taxpayer, you've called us. Why are you calling us? The taxpayer will say, I received a notice of refusal that I should pay 1 million naira. After I have written a notice of objection, objecting to the assessment that this is bogus, this is preposterous, this is humongous, this is something that is, you use all your languages and, you are telling them that why you are not going to pay that tax. You filed this, you brought this, you complied with that. These are my statements. I have provided this statement. This is my bank statement. This is my financial statement. This is my evidence. And they still say I should pay after all these evidences. I also have witnesses that I need to call. Oh yeah, I have my lawyer here. He's a witness. I have my banker. He's a witness. I have my accountant. I have so and so customer. They are all witnesses. So after having exhausted his statement and his witnesses, the respondent is the accused. Not you will not call them accused. You will not call them the defendants. You can call them defendant, but they are not in court. So we don't use plaintiff, we don't use defendant. We call them appellant and respondent. So the respondent, it could be the tax authority, or they could change places. The tax authority might be the one dragging, and the taxpayer will be the one responding. So the respondent or his representative, who may be a lawyer, accountant, or anybody, may in like manner present any document or statement and may call his own witnesses to counter what the appellant had said. So it's being done like court, but you will not hear them say, objection, my lord. No, but this is not a court. The tax appeal tribunal is not a court, but it is acting like a court. The chairman is a legal practitioner, and so where they are sitting, they will have the decorum of the court, but it is not a court. At the hearing of an appeal, the tribunal shall admit all relevant evidence, which could be oral or documented, which will be produced by the appellant or the respondent or any person that is appearing on their behalf. So the witness could also bring any document to show that this is evidence. They admit it. The evidence could be against the appellant, could be against the respondent, come from anywhere. The tax appeal commissioners sitting will admit all of this evidence when they are hearing the case. All right. Then the oral examination of a witness during his evidence in chief shall be limited to confirming his written disposition and tendering in evidence all documents or other exhibits referred to in his deposition. So, of course, there will be an oral examination of witnesses. Then the other party may have to cross-examine the witness, just the way they do in court. You hear an examination, the first examination, you will say any cross-examination, They will cross-examine. After that, they may want to say, do you want to re-examine this witness? And if that, well, then the witness may be dismissed, another may be called. Where the tribunal deems it necessary, it may call upon or permit any party to produce additional documents or call additional witnesses or file any affidavit to enable it to issue proper directions or order. Now that's at the discretion of the tribunal. So you see here, oral evidences are admitted apart from written evidence. The party that is called as a witness will examine and cross-examine. Where the tribunal, on application of any party, directs that any person shall be summoned or to give evidence or tender any document, the tribunal may order the deposit of such amount of money before the issue of a summons as in Form 36. So this is to cover the expenses of such a person attending. So these are just the procedure. So where a witness does not appear to a summons, the tribunal may, upon proof of service of the summon, issue a note of a warrant to bring such a witness before the tribunal at any time that may be convenient. So we see here that these are just procedures. What the main thing is that you are coming before the tax appeal tribunal. One, you are there to present your case. Two, your case could be written, could be oral. Most times it's oral. You hear oral discussion or written evidences could be admitted. Your witnesses will be called upon. Witnesses will be examined, cross-examined, re-examined, and anybody who is summoned and is refusing to come may be forced to come with an issue a warrant. Now, what are the qualifications for any of the 40 people who wants to be a tax appeal commissioner? What are the qualifications? A person shall not be qualified as a tax appeal commissioner unless he is knowledgeable in the laws, regulations, norms, practices, and operations of taxation in Nigeria. So that's one. Knowledge of this. Then, as well as persons that have shown capacity in the management of trade or business, or retired public servants in the tax administration. So management. So knowledge plus successful management makes you a candidate for tax appeal commissioner. So it's not anybody who is a lawyer who knows tax practice. You must have known that. You must also have either worked in the public tax office, or you are you have shown that you have a capacity to manage your own trade, your own business. So if you are working in an audit firm, in a tax firm, you've managed it successfully, you can be called. You are also maybe a member of the Big Four. You are also shown that you have demonstrated, you can be called. So it means that you must be qualified on paper first. Qualified on paper means you must also become an member of the association. Then you also have to be knowledgeable. So it means that as you are building up your knowledge of tax matters, you are building up yourself for possible appointment as a tax appeal commissioner. So it means that the minister at any time may choose to appoint anyone, and you see it's from the 6 geopolitical zones. So they can just decide to choose you one day as a tax appeal commissioner and you'll be in a particular zone. Now, what are the terms of office of a tax commissioner? The 5 people in a zone or the 40 people will hold a term for 3 years, which can be renewable. So it means for 6 years. What does that mean? It means that, excuse me, it means that it's possible that two tax appeal commissioners, two sets, they run during an 8-year presidential rule, or even two sets may run during a 4-year presidential rule. But that's not our problem. Just know that you are going to hold a term. Your first term is 3 years. And if you are doing well, it could reappoint you for another term. So it means that some people could get reappointed, some people may get not reappointed. While some people are finishing their second term, some people will be finishing their first term concurrently. Now, once you attain the age of 70, you are no longer qualified to be a tax appeal commissioner. So it ends before you get to the age of 70. So if you are appointed as a tax appeal commissioner, maybe you are 68 years then, and by your second year, you are 70 years. You won't wait for the 3 years to complete, you will resign. So whichever comes first, 70 years or your term of service, whichever comes first. Resignation and removal of a tax appeal commissioner. A tax appeal commissioner may, by notice in writing, resign his office, provided that the tax appeal commissioner shall, unless is permitted by the minister to relinquish his office sooner, continue to hold office until the expiration of 3 months from the date of receipt of such notice, until a duly appointed person succeeds him, until until the expiration of his term, whichever is earlier. So if you are resigning, it's just like when you want to resign from your office, they give them 2 weeks notice or a 1 month notice. This is 3 months notice. Except the minister wants you to leave office immediately, but 3 months. And you will continue to hold office until they get a replacement for you. The replacement may come maybe in the first month of notice or in the second month of notice, then you end your office, the person takes over. But until your office expire or they get someone to replace you, whichever comes first. A tax appeal commissioner may be removed. This time around, you are not resigning, you are removed on the grounds of gross misconduct. What could become gross misconduct? Maybe you are taking bribe before you render your judgment. You know, there are some people who want to use to ask you to give them your body, then in return for this favor. That's gross misconduct. Or incapacity. You are not capable. After due inquiry has been made and they find out that you are not capable, you could be removed. And the tax appeal commissioner will have to be informed of the reason for his removal after being given opportunity of being heard. So you will be given an opportunity to present your case. You will be heard. Then when you are heard, you are going to either you'll be told the reasons why you are being removed from office. So now you see here, one, there are 3 ways the tax appeal commissioner will leave office. One, if his tenure expires. Now, if his tenure expires, he can renew it if it is renewable. If it is not renewable, he leaves the office. Second, his tenure is not expired yet. He may write to resign. He may write to resign. Of course, um, we have the 70-year and 70-year of age of attainment. That is a natural way of leaving office at the end of a term. Then resigning is another way. Then removal from the office due to gross misconduct. So this may come up in your exam. So if you're talking about the tax appeal tribunal, talk about the composition. There are 5 people in a tribunal in a zone. There are 8 zones in the federation. So there are 40 tax appeal commissioners. They must have a chairman who must be at least 15 years legal practitioner. They must also have a secretary, then other members. These people must be knowledgeable in tax matters, and they may also have the capacity to have managed their trade or business successfully or be in the public service tax management. Then we have said that they can be in office for 3 years, renewable once. So which means they have a maximum of 6 years, and or attainment of 70 years, whichever can be removed from office for gross misconduct, or they could voluntarily resign and must give notice at least 3 months to the date they are planning to leave. Now, are these people doing their job for free? No. There are salaries, allowances, and condition of service for the tax appeal commissioner. The salary and allowances payable to these people shall be determined by the Revenue Mobilization Allowance and Fiscal Commission. Just remember this name, Revenue Mobilization Allowance and Fiscal Commission. Revenue Mobilization Allowance and Fiscal Commission. How you try to remember this name, I don't know. They shall prescribe in their letters of appointment what their salaries should be and what their allowances should be, and their terms of condition. Now, if for any other reason other than temporary absence, a vacancy occur, it could be death. That's another way of naturally leaving office, death or insanity. So if any vacancy occur other than temporary absence of in office of a tax commissioner, the minister shall appoint another person in accordance with the provision to fill the act. So it means that if someone from, let's say, a particular geopolitical zone resign, they may have to appoint someone from that geopolitical zone. They may have to appoint from that maybe uh, geopolitical zone. When I mean geopolitical zone, let's say the South. It doesn't mean that it must be from the same state. Let's say the person who was there, it could be the chairman. Let's say the chairman for Southeast could be from Enugu State and he resigns or so. They could take from another state or from that same state and fill in the position. All right. Constitution of the tribunal. The question as to the validity of the appointment of any person as a tax appeal commissioner shall not be the cause of any litigation. So the validity of appointment should never be a cause of litigation. in any court or tribunal, and no act or proceeding before the tribunal shall be called into any question. So when you are being served to come into the tax appeal tribunal, you cannot question the validity of the appointment of any person. All right? So we said before there is a chairman, there is also a secretary. The minister shall appoint chairman also first, then the minister shall also appoint for each place or zone a secretary. What will the secretary do? Subject to the general control of the tax appeal commissioner, the secretary will be responsible for keeping records of the proceedings of the tribunal. So it takes down the minutes, the procedures of the tribunal. Also, he will be the head of the secretariat and be responsible for the day-to-day administration. So the secretary is like the chief of staff, is the one who is responsible for the day-to-day administration. Whereas the chairman is the chairman at the tribunal sitting. Then the secretary should be responsible for direction and control of all other employees of the tribunal. The official address of the secretary appointed for each zone shall be published in the Federal Gazette. So secretary is a very important person. So after the chairman, secretary is being appointed. Appointment of one of other staff of the tribunal. The minister shall appoint such other employees as may deem fit for the efficient performance of the function of the tribunal, and remuneration of persons so employed shall be determined by the National Salaries and Commission. So what are they saying here? Apart from the 40 TAC that have been appointed by the minister, the chairman for each of them is being determined, secretary for each of them has been determined. So the other three members are members. There are other staff. Of course, the 40 people are not the ones going to be doing all the job. They may have a typist or a secretary, maybe a PA. PA is the right word. PA to the chairman, PA to the secretary. They may have some other office assistants. They may have different other staff as may be deemed necessary for the performance of their duties, and their salary shall be determined by the National Salaries and Wages Commission. These people keep confusing us. NSWC. Whereas that of um, the terms and allowances and salaries of the appeal commissioners are from Revenue Mobilization Allowance and Fiscal Commission. Why not allow one person to do the job? I wonder why. But just note what happens here. These are the people that determines the other staff that is employed. The employment of the tribunal shall be subject to the provisions of the Pension Reform Act and other benefits that are given to retirees, so their retirement benefits. So some of these are not as important as some others. So the ones that are important is here, the composition of the TET, that's one. The qualification and term of office, removal and resignation, appointment of secretary. Now look at the jurisdiction of the tribunal. The tribunal have powers to adjudicate. That means they have powers to hear and render judgments on disputes and controversies arising from the following tax laws. We have the Company Income Tax Act. So that means between any company and the Federal Inland Revenue, they can also adjudicate over Personal Income Tax Act. So between a natural person or a business name and the Federal Inland Revenue. Then we have the Petroleum Profit Tax Act. This concerns the petroleum companies. Then we have the Value Added Tax. This could concern both individual and businesses. The Capital Gains Tax, businesses and individual. Then any other law contained in it or specified by the first schedule. Because we have the Stamp Duty Act, the excise duty, all of them are also contained there. So they have the power to adjudicate, hear, listen disputes, and render judgment over these tax cases. So that means they have to be knowledgeable in these areas. And when they are also handling their duties, they must have demonstrated that they have the competence. So if somebody who is not competent is now being asked to judge, they will render his judgment as ineffective. The tribunal shall apply such provisions of the tax law referred to as above, and it can apply it in the determination of the outcome or the resolution of any dispute before it. So it means that if there is a Company Income Tax Act that is in question, they might apply the relevant section of that Company Income Tax Act to solve a problem. Criminal prosecution. Where in the course of its adjudication, the tribunal discovers evidence of possible criminality, the tribunal will pass such information to the appropriate criminal prosecuting authorities, such as the Attorney General, Federation, or for any state, or any law enforcement agency, let's say the EFCC, ICPC. They are obliged to pass on that information because that's a criminal evidence that they discovered. So while they are judging tax matters, find a criminal evidence, pass it on to the appropriate quarters to handle that because that is not their jurisdiction. Now we've talked about the Tax Appeal Tribunal. How did we get to that point? We mentioned that a taxpayer will assess himself to tax. Self-assessment. He goes on Tax Promax, file the self-assessment, and off it goes. The tax authority, the Federal Inland Revenue, receives it and they do a DEX examination. They look at it. Is this adequate? Oh, yes, it is. We accept it, we admit it in. When they check, it is not adequate. Wow, we have a problem. Maybe some tax laws were not followed. Maybe some revenue were being hidden and they think we don't know. Maybe they check and they see that maybe the revenue you declare for VAT is not the same as the revenue you are declaring for income tax, and there's a difference. And they are telling you, yes, we know that you have some revenue that you are not showing, and they now give you an assessment and they send it to you. This is a notice of assessment. Maybe you didn't even do your self-assessment and they come and they give you a notice of assessment, sometimes called best of judgment, because you didn't file. They give you the best of judgment notice of assessment. They give it to you. Once you receive it, you have 60 days to pay that. Otherwise, the law will force you to pay. But while the 60 days is counting, you have 30 days to decide whether you agree with this tax forced on you or not. If you agree, fine. If you don't agree, within 30 days, you must write a valid notice of objection. It must be in writing, it must be made within 30 days, and must state the grounds for objection. Now, when they receive that letter, they will review it. Wow, this taxpayer is making some points. Wow, we didn't look at it that way. Oh, now we are seeing it in a better light. All right, taxpayer, we agree with your assessment. We give you a revised assessment. Go ahead and pay what you have to pay as contained in your notice of objection. We admit it in, we accept it. That's fine. Everybody shake hands and they go in peace. Now they look at the assessment. They say, this taxpayer is not making sense. What are these evidences bringing? It doesn't add up. It doesn't mean uh, we do not agree. So even though you have raised an objection, they will, instead of giving you a revised assessment, they will rise back and say notice of refusal to amend, NORA. So in Nigerian parlance, they will say, and I no gree, they tear clothes. The tax authority do not agree, you yourself do not agree, you have tried to make them see your own point of view and they are not shifting ground. Who should you go to? You go to the tax appeal tribunal. You now have to file a notice of appeal to the tax appeal tribunal. It must have to be in the zone covering where you are having your business or where you are locating, considering the kind of tax law that is being in question. Now you go to this tax appeal tribunal, they say from COVID era, you can have video conferencing or you can meet in person. Chairman will be there, the secretary, all the five people, but at least three people will be there. The chairman is not there, they can appoint somebody to be the chairman. The chairman must be a member of the Nigerian Bar Association, must be a practicing tax lawyer or barrister at least for 15 years. And now they sit on the case. Oral discussions being done. The appellant will be called to bring his witnesses, make his statement to prove his point. So he who comes to the tax appeal tribunal, the onus is on him to prove his case. Brings his witnesses, examine, cross-examine, re-examine the appellant. So just look at it now. The person who brings the tax appeal tribunal to sit is the appellant. The one who is responding to allegation is the respondent. The respondent shall bring his own evidences, oral, written, witnesses. They will be examined, cross-examined, re-examined. The tax appeal tribunal will determine the outcome. And they are adjudicating over about 8 laws. When they find anything criminal, they pass it over to the what? Relevant authorities. Now, appeals to the tribunal. All right, let's look more at the appeal to the tribunal, though we've talked about the appeal to the tribunals before. Notice of appeal. The notice of appeal in writing must specify the official number of the assessment. We said the assessment number, the date, and the year for which that assessment was made. The total profit on which the tax was charged on, the amount of tax charged, what is the date of service of the NORA, what are the precise grounds for the assessment for the appeal, and it must be the same as the ground stated for objection. then the address for the service of any notice, correspondence, or document to be given to the appellant by the secretary to the appeal commissioners. Now, if all notices, documents, and correspondence given to the appeal commissioners shall be addressed to the secretary of the appeal, writing. Now, a company may discontinue any appeal by giving a notice to the secretary at any time before the hearing. Anytime before the hearing. Notwithstanding that a company has given a notice of appeal against an assessment, the revenue may revise the assessment in agreement with the company. The revenue shall also give notice in writing to the secretary of the appeal commission at any time before the hearing that this hearing should be discontinued. So not when they started the hearing, you now say let this hearing be discontinued before. So it could be that they have come and they say, oh, sorry, we don't think the appeal should hold again. All right, they disband it. But not when it has started. Notice of refusal to amend. When a notice of refusal to amend has been received by a company, the company, if it desires, can appeal against the assessment upon giving notice of appeal in writing to the secretary of the appeal tribunal within 30 days. We have stated it. A late appeal may be accepted upon an application being made to the tax appeal tribunal if there is reasonable excuse for the delay. For example, it could be postal delay. That's why some people usually like to use DHL. Or you could go there and have it being stamped, or maybe because of distance, it could be uh, delayed. And sometimes maybe because there is strike, the appropriate people that should take this letter are on strike, it could get delayed. So if there are some of these extenuating circumstances, it could be accepted. A late appeal could be accepted. But if you are waiting for the last minute to appeal, why did you wait for the last minute to appeal? Then it may not be tenable. Appeals from decision of the service. An aggrieved person, a person aggrieved by an assessment or demand notice made upon him by the FRS, or aggrieved by any action or decision of the service, may appeal against such a decision or assessment within 30 days. An appeal under this schedule shall be filed within 30 days from the date this decision was copied. Now, if it is not filed, then it is taken as acceptance. Now, it shall file it and accompany it with such fee as may be prescribed by the tribunal. Where a notice of appeal is not given by the appellant within 30 days, then the appeal, the assessment is said to be final and conclusive. So take note of this language, final and conclusive. That's a very important language we shall know. So they can tell you when is an assessment deemed to be final and conclusive. One, when there was no notice of objection within 30 days of the service of a notice of assessment. It is final and conclusive. Now, if there was an objection and there was a refusal to amend and no notice of appeal was filed within 30 days, the assessment becomes final and conclusive. And when an assessment is final and conclusive, it means that the tax, the interest, the penalties will be paid by the person bearing the liability. Appeals by the service. Now, where the service is agreed by the non-compliance by a person in respect of any provision of the tax law, it may appeal to the tribunal where the person is resident, giving notice through the secretary to the appropriate zone of the tribunal. Normally, the tax authority has the right to, take some actions, but sometimes some people will be non-compliant, and there may be persons placed in high authority, somehow sacred cows, you can't touch them or so. They could file in an appeal to the tax appeal tribunal and bring them to the tribunal to be questioned. Procedures before the tribunal. What are some of these procedures? One, the tax appeal commissioners shall meet to hear the appeals in the jurisdiction or zone that is assigned to that tribunal. They will never go to any zone. Lagos will not go to Ibadan, and vice versa. Two, where a tax appeal commissioner has a direct or indirect financial interest in any appeal, or where the taxpayer was a client of that tax appeal commissioner in his professional capacity, he shall declare such interest to other tax appeal commissioner and refrain from sitting. So you see why 3 is the minimum, and it doesn't mean that the whole 5. So the whole 5 could be there, and when they receive it, they say, oh, this person that is dragging these people to tax appeal tribunal, he used to be my friend. I used to work for him. He was my client before. Or this person is my relation, or is my sponsor, is kind somehow related to me. And so the, how will I call it? Um, Familiarity or this kind of relationship will disqualify such a person from having the capacity of sitting down. So he will be biased. So you need to disclose such relationship and refrain from sitting in that meeting. It's just like saying that you are somebody who is coming to be interviewed in a place where his friend or somebody he has close relationship is going to be a panel. To be unfair if he sits and also determine the outcome of his fate. It will not be a free and fair playing ground for all others who came to get a fair hearing. So the same thing here. So he has to leave. The third one, the secretary to the tribunal shall give 7 days notice to the service and to the appellant, now the service is the FIRS, and to the appellant of the date and place fixed for the hearing of each appeal, except in respect of any adjourned hearing for which the tax appeal commissioners have fixed a date at their previous meeting. So if they're just meeting for the first time, the secretary will write within 7 days where they are going to have the hearing and the date and time. But if they are already in a hearing and they cannot complete it that day, they can adjourn. And so the secretary will not need to write again because the date of adjournment was announced at their meeting. All notices, documents, other than decision of the tribunal may be signified under the hands of the secretary. So every other document is held in the hand of the secretary. The decision of the tribunal is out of his hands. He is not the chairman. The decision is out of his hands. All appeals before the tax appeal commissioners shall be held in public. So it means that the public can walk in and sit, just like in court. You can walk in, nobody will say, "Hey, Mr. Man, what are you doing here?" As long as you hold yourself in a manner worthy of listening in. So it means that some people can, for the purpose of having knowledge, for the purpose of experience, can go there and have that. Of course, when they are holding it in um, um, through video conferencing, it might be restricted. It might be restricted. It's not something that they will now share the Zoom link for everybody. But if it is a public place, they will go there and held in public. Now, the onus, I like that word. Now, the burden of proof, the onus, the burden of proof of providing that the assessments complained of is excessive shall be on the appellant. So you call the tax authority, you drag the tax authority FRS to the tax appeal tribunal. You are the one to prove that they gave you an excessive assessment. They gave you something that is grievous. They gave you something that is preposterous, something that is excessive, and it is not adequate. You have the right to prove. So the burden of proof is on you, it's not on the FRS. So if you can prove your ground beyond reasonable doubt, then you may get a favorable hearing, especially when the FRS cannot refute it. Now, at the hearing of an appeal, if the representative of the service proves to the satisfaction of the tribunal hearing the appeal in the first instance that one, the appellant has for the year of assessment failed to prepare and deliver to the service returns required to be furnished under the provision of the tax law. If it proves that they fail to prepare and deliver, that's number one. If they also uh, prove that the appeal is frivolous, vexatious, or abuse of the appeal process, or that it is expedient to require the appellant to pay an amount as security for prosecuting the appeal, the tribunal may adjourn the hearing to a subsequent day and order the appellant to deposit with the service before the day of adjournment that amount charged by the assessment under the appeal, and which is equal to the tax charged upon by the appellant for the preceding year of assessment, or one half of the tax charged by the assessment. So it's either they pay what they have been paying preceding year, or one half of the tax charged in the current year, whichever is lesser, plus a sum equal to 10% of the deposit. And if the appellant fails to comply with this order, the assessment against which he has appealed shall be confirmed, and the appellant shall have no further right of appeal with respect to that assessment. So if he fails to comply with this, he shall forfeit the right of appealing. So this is a very serious thing. If anybody wants to appeal and the hearing, the FRS or the respondents prove all of this, right? Now, the tribunal may, after giving the parties an opportunity of talking, being heard, they can confirm the assessment. They can reduce it. So when they say they confirm, they ratify it. All right, It means that I agree with the FRS. Mr. Pay this personal income tax levied on you. They might say, I agree with the FRS, but it will be reduced. They could increase it or they could annul it or make any decision or judgment as it deems fit. Now, when they have made that decision, every decision of the tribunal shall be recorded in writing by the chairman. So you see, that's the document that will be in the chairman, not the secretary. And subject to the provision of paragraph 16, a certified copy of such a decision shall be supplied to the appellant or to the service by the secretary upon request made within 30 days of that decision. So they make a decision, the parties that are, that it favors, even those that even lost, they could make a copy, a request that such a decision shall be made to them in writing and it will be sent to them. Now, whereupon hearing of an appeal, no books, no account, no record relating to profits were produced, either by the appellant or by his representative, that's one, or if such a book was presented or record were presented, it was rejected by the tribunal on the grounds that it had been shown to its satisfaction that they were incomplete or unsatisfactory, or the appellant or its representative at the hearing of the appeal has neglected or refused to comply with a notice delivered or sent to him by the secretary to the tribunal without any showing reasonable cause, or the appellant or any person employed, whether confidentially or otherwise, by the appellant other than his legal practitioner, other than his legal practitioner or accountant acting for him in connection with his ability to tax, has refused to answer any question put to them by the tribunal without showing any reasonable cause. The chairman of the tribunal shall record particulars of the same in his written decision. So when they are making the judgment, they could say the appellant failed to produce books, records. If they were produced, these were inadequate, they were incomplete, and when we put questions to their representative, they failed to answer and without giving any reasonable cause. That will also have an impact on the judgment. So now we have seen the tax appeal tribunal, they could ratify the assessment, they could increase, they could decrease, they could annul. So they could uphold it, they could adjust, they could annul. Now, if you are getting the judgment from the tax appeal tribunal, you can make a written request that this judgment be given to you. Now, what happens after the tribunal sits and judgment is passed? One person will be aggrieved, one person will rejoice. What happened? The notice of the amount of taxable charge of tax chargeable under the assessment as determined by the tribunal shall be served by the service upon the taxpayer or upon the person whose name is written. So it means that if the judgment is saying that this is a judgment tax, so the judgment tax is a tax judged by the tax appeal tribunal. Now they are going to write an assessment, that's the FRS will write an assessment and serve it on the taxpayer. Now, an award of judgment of the tribunal shall be enforced as if it were a judgment coming from the High Court. Now, can you see why the chairman should be a legal practitioner because his judgment will be coming as if from the High Court. Upon registration of a copy of such an award or judgment with the Chief Register of the Federal High Court by the party seeking to enforce the award or the judgment. So they've given their judgment, collected it in writing, the decision. They are going to go to the registrar of the Federal High Court and seek a registration of such a copy so that they can take that copy and enforce it. All right. Now, notwithstanding that an appeal is pending, tax shall be paid in connection in accordance with the decision of the tribunal within 1 month of notification of the amount of tax payable. So an appeal is pending, they have now make a decision, you have to pay within 1 month. Now, what happens if one of the parties, the one that lost, is dissatisfied? Any dissatisfied person that is dissatisfied with the tax appeal tribunal decision shall appeal to the Federal High Court. So you see, this is second appeal. The first one was notice of objection to the Federal Inland Revenue. Second thing was notice of appeal to the TET. They are dissatisfied with the outcome, notice of appeal to the Federal High Court, and this shall be given in writing to the Secretary of the TET within 30 days. So now you're not writing, you're writing to the Secretary within 30 days after the TET has given its decision that you are appealing to the Federal High Court, and the appeal must be based on points of law. That is important. A decision, a notice of appeal filed pursuant to subparagraph A shall set out all the grounds of law on which the appellant's case is based. So when you are saying it to the Federal High Court, you are giving a point of law. If the service is dissatisfied with the decision of the tribunal, it may also appeal such decision to the federal government, Federal High Court. So the first one was a person. Now it is this service. Maybe they award the judgment to the person. The Federal Inland Revenue is not happy. They could also do that within 30 days. Now, upon receipt of a notice of appeal, the secretary to the tribunal shall cause the notice to be given to the Chief Register of the Federal High Court along with all exhibits tendered at the hearing during the tribunal. So they have written, we are not happy with the decision. We are pursuing it further to the High Court. The secretary will tender every exhibit it has collected and give it to the registrar, Chief Register of the Federal High Court. So it is out of the hands of the Tax Appeal Tribunal. It is now a case in the courts. The Chief Judge of the Federal High Court may make rules providing for the procedure in respect of appeals made under this Act. Until such rules are made, the Federal High Court rules relating to the hearing of appeal shall apply to the hearing of an appeal under this Act. So here, the judge is making a rule that will govern the procedure that will be, taken when it is now time to hear the case in court. Now, when you were having the tax appeal tribunal sitting find out that it is not a court. And so there may be no need for lawyer, there may be no need for legal representative. You may just have your accountant, you may just have your tax practitioner, even representative of your office may just come and represent. But in this case, when it is appealed to the Federal High Court, a complainant or appellant may either appear in person or authorize one or more legal practitioners to represent him before the tribunal. Every individual or company in a case before a tribunal shall be entitled to be represented at the hearing of an appeal by a solicitor. Take note here, a solicitor, or who? A chartered accountant. I need to, for emphasis, a solicitor or a chartered accountant or advisor, provided that if the person appointed by the taxpayer or representative in any manner before the tribunal is unable for good use to attend the hearing thereof, the tribunal may adjourn the hearing for such a reasonable time as it deems fit. So you see here, who are the people that could represent? Solicitor is the first option because he's a lawyer. Now that means the person must also be familiar with law and taxation. Chartered accountant and advisor. Now, there is a power and procedure of the tribunal. The tribunal may make rules regulating the procedure. The tribunal shall set for the purpose of discharging its function, have power to one, summon and enforce attendance of any person and examine him under oath. It can have the power to require the discovery and production of documents, receive evidence on affidavit, call for the examination of witnesses or documents, review its decision, dismiss an application, decide matters ex parte, order or dismiss any application, do anything that in his opinion will be right done in the court. Now, in all of this, the court may rule. Now, when the court may rule to favor one person another, but before they rule, just like the tribunal may have something that is criminal, any proceeding before the tribunal shall be deemed to be judicial proceeding, and the tribunal shall be deemed to be a civil court for all purposes. So that's for tribunal. But here, for the High Court, it is a court on itself. So the court decorum should be attained. So the court will rule and it may favor one party or it may favor no the other party, or they may dismiss the case in the case may, as the case may be. Now when they rule and one of them is aggrieved, they can take the matter to the appeal court of appeal. You can take it to the court of appeal and the same court process follows. Then it could even escalate to the point of going to the Supreme Court. And when it goes to the Supreme Court, that is the final part where the case is determined. So now a question may be asked: when is a tax judgment, when is a tax seen to be final and conclusive. So that's the language, final and conclusive. One, if there was no notice of objection within 30 days, it is final and conclusive. If there was an assessment and it was not objected to within 30 days, it is final and conclusive. Now, if there is an objection and it came with a notice of refusal to amend, which is NORA, and it was not objected to within 30 days, so that means there is no notice of appeal within 30 days, it is final and conclusive. Now, when there is an appeal rules, and there was no appeal to the Federal High Court within 30 days, it's final and conclusive. When the Federal High Court rules and someone lost, they have to be appealed to Court of Appeal within 30 days. If it is not done within 30 days, it's final and conclusive. Now, where the decision of the federal of the Court of Appeal doesn't go down with you, and you don't appeal to the Supreme Court within 30 days, it is final and conclusive. Now, you go to the Supreme Court and they rule. Once the Supreme Court rules, the judgment tax is final and conclusive. So that's it here on the Tax Appeal Tribunal. This is objection, tax dispute resolution. How do you resolve taxes dispute? First of all, you try to resolve it amicably within the Federal Inland Revenue and the taxpayer by talking it out, send a notice of objection, peaceful. They refuse, after all said and done, gave you a refusal, not shifting grounds, you go to the Tax Appeal Tribunal, notice of appeal. You are the appellant, you are the respondent, you still lost, you go again and seek to get redress in the court, Federal High Court. You go and you lost, seek further redress in the Court of Appeal. You go, you lost, it's possible you could seek redress with the Supreme Court and win. And when you win, it's final. You lose, and everything is crashed down on you. The case, the judgment is final and conclusive. So that's the summary of this topic. Know that the Tax Appeal Tribunal, there are 40 in number, 5 in a zone, having a chairman, secretary, 3 members, 3 people form a quorum. Their tenure is 3 years, renewable ones, can be removed from office, they can resign, they can be vacant from office, they can leave out their tenure, they could attain to the age of 70 and leave office. Someone could even die and leave a vacancy in the office. So all of these things could happen. Their mobilization, their wages is being prepared by the, what's that name again? We get that long name. Revenue Mobilization Allowance and Fiscal Policy Commission. Fiscal Commission. They determine the condition of service and the salary and allowances of the appeal commissioners. Now there are other staff that could work for them, and their revenue uh, are being determined by the National Salaries and Wages Commissions. So these are some of the things you could need to know about the uh, objection or dispute resolution. So you could get a past question. Get a past question. Let's see if there are anything here that lends to that topic before we call it a day so that you can go through. So, so this is not it here. Into the wrong place. Okay, so open this now. All these not the documents I'm asking for. All right, I'm opening the right one now. All right, so let's see. This question is not it. Not here. Not here. Not here. Not here. Best of judgment. So I suspect here. I suspect here. So you could give attention a bit here in 19 because of this best of judgment assessment. Let's check again. Okay, there's another one here in 19. It's objection and appeal. Okay, so we've seen one there. There's another one here in 19. So you can see now that these things happen here. You can find out how these questions are being done. So thank you so much for coming to class, and I look forward to seeing you in my next class when a different topic will be discussed. Thank you once again, and do have a wonderful day. Bye bye.